Hello, hello, hello. Are you ready?
I'm ready.
Okay, I think I'm ready. Let's do a podcast. Hello, and welcome to Learning the Law, a podcast about all things legal with a focus on current events, where we try to teach you things in an hour. My name is Ashley, aka Phoenix Nymphy, and my co host, who is the man of the hour, the man with the knowledge, my husband, Ron. This
Hello.
podcast is purely educational and should not be taken as legal advice. This podcast does not create an attorney client relationship. This podcast is based on his interpretation of relevant law, and any opinions expressed are the opinions of the individuals making them and do not reflect any opinions of any firm, company, or other individuals. Ron is a licensed practicing attorney here in the state of California.
Yes, I am. Since 1999.
This week, the podcast is sponsored by lawyer.com. With 10 plus years of matching experience and technology development, lawyer.com is proud to make thousands of lawyer connections each week. Lawyer.com connects users nationwide with lawyers in all areas of law. Please use our referral link to help out the podcast and find yourself a lawyer in your area. We will post that in all the places that you can find it. It definitely helps out the podcast. But
Yes, it does.
uh yeah. So today was a full day for me. But yeah, so welcome in. Today is the start of our mini series that we have been threatening to do for a very long time. Roe v. Wade. I know many people have actually been just like discussing it and talking and asking questions. So we hope to address a lot of your concerns here in this mini series. So welcome in. But we like to start this podcast off. If you've never been here before, we like to start this podcast off by just kind of discussing our weeks. So how has your week been?
My week's been pretty good. Haven't done much as far as Warcraft goes because I'm not on the progression team in the raid, but it's still fun. And work has just been constant, which is fine because I love the work I do now.
We're not a gaming podcast so I don't think anybody really cares what you do and well. I'm just putting that out there.
Oh,
I don't play
I,
that game anymore. I don't care.
I realize that, but you asked me how my week was.
um Today was a very busy day for us. Next week we might, so I will say next week's podcast is a maybe. It might be a situation where we actually record it and then post it live, only because I do have surgery next Monday. It's probably going to be in the afternoon because it's a minor surgery. Everything's okay. I have issues with my menstrual cycle, so we're just kind of trying to figure stuff out down there. My people who menstruate, they totally understand. I know y'all do.
It's
So next
it's
to
like an exploratory surgery, kind of.
yes. Anyway, I know that a lot of people get really, there's some people who get really when you talk about that kind of stuff. So I'm not going to go into too much detail, but it is to help me get better. So next week's podcast is going to be possibly live, more likely, or it's going to be recorded and posted at a later time because I don't know how I'm going to feel next Tuesday. We don't have any questions from the audience, but we have an update on the DOJ lawsuit?
We do.
Okay, all right.
And the Supreme Court is actually going to hear arguments on the lawsuit November 1st. They've moved it up because there was an asking for expedited hearing.
Yes.
And so it's actually going to be heard before the Mississippi or Missouri,
It's Mississippi. It's a Mississippi
Mississippi, okay,
lawsuit.
the Mississippi abortion law, which bans it after 15 weeks.
So this is actually really important because, and we'll really go into detail starting today about why this is so important. Because if they decide to side with Texas, then it will absolutely overturn everything that exists with Roe v. Wade, which means that women lose their decision making for their own bodies. But it also means that as a whole, the American people no longer have a right to privacy, and among other things. So we will. That's Roe v. Wade is not just about abortion. That's why the title of the podcast is Roe v. Wade. It's not just about abortion, because a lot of people don't realize that. We have a lawsuit against. We have an update on the lawsuit against Activision Blizzard, which is nice. What is that update?
The update there was Activision Blizzard has attempted to halt the lawsuit because a couple of the attorneys working for the DFEH, the one that brought the state investigation against Activision Blizzard, previously had worked for the EEOC, which is the federal
What does that have to do
agency.
with anything?
We're getting to that.
Okay.
The federal agency that instituted an investigation.
Right.
And so now Activision has said those attorneys that worked on the EEOC investigation, working on the state of California investigation, was a conflict of interest.
How?
In that they built on knowledge that the federal government had that the state government shouldn't have had.
But the state government would have gotten that information anyway. So how is that even
possibly?
Okay.
If the state government did not know about an EEOC investigation, they wouldn't have had that information initially. They wouldn't have had it until the EEOC had come out and said, hey, we're going to settle. I mean, we're going to sue Activision Blizzard, which didn't happen until after the state of California sued Activision Blizzard.
It sounds to me like they're reaching.
They are. The judge said the judge threw out the attempt.
Oh, okay. All right, cool.
So that, not every update, is going to be something phenomenal, but that's the latest update.
And okay. We told y'all we would keep you updated on these things. So, yeah, that's your update. They're trying, man. They're trying real hard, aren't they?
They are, because it could be considered an ethics violation and something the Activision Blizzard could use to get the case thrown out entirely. But the judge, and the judge's name is Timothy Patrick Dillon, rejected the request.
That's a white boy name.
Yeah. It also, it's the 3-name thing. Serial killers usually have 3 names.
Yeah. I will say, just a little side note to those people who left Blizzard and created the game studio Notorious Studios. The fact that you have a dog on your main page, but not a single woman or a person of color. There are a few guys who look like they could be maybe Middle Eastern or Indian, but they all kind of are white passing. You're not actually striving for a more diverse company, because your company's not diverse. You failed. You're doing the same thing that Blizzard did. You suck. So, yeah, I'm sorry, but that is a pathetic attempt at claiming diversity. Pathetic. Okay. All right. Moving on.
Okay.
Let's get to Roe v. Wade. And I'm going to let Ron lead all of this because he is the one who has done, like, yeah, he's the one who has the most information. I mean, didn't you have like a whole class or something on Roe v. Wade,
Well,
or don't they have
it,
whole classes on Roe v. Wade in
it's a very
law
large
school?
section of your constitutional law education.
Yeah. So,
So, first, I will have a question for you.
okay.
When I say Roe v. Wade, what does that mean to you?
So, prior to like the research that we've been doing for this, whenever I thought of Roe v. Wade, I always thought of it as the abortion rights law. That's what I've always known it as.
Okay, and
That was it.
abortion is legal because of Roe v. Wade. Period.
Yes.
Nothing else.
That's all I knew. And yeah.
Okay. Well, I will tell you what brought about Roe v. Wade.
Okay.
First of all, it was a Texas
Texas
statute
agreeing.
that prohibited abortion except when necessary to save the life of pregnant women.
Very similar to the one that exists right now.
Right, except there's no exception for
Yes.
saving the life of the mother.
Right.
Okay. The Supreme Court, in a decision written by Justice Blackmun, recognized a privacy interest in abortions, and in doing so, applied the right to privacy established in a case called Griswold v. Connecticut in 1965.
Okay.
And at stake in this matter was the fundamental right of a woman to decide whether or not to terminate her pregnancy.
Okay.
Yeah.
What it was what now? What was the case?
Griswold v. Connecticut.
Griswold v. Connecticut. Which
Okay.
Thing are you following here?
The Cornell Law School little nutshell.
Okay.
And so in order to understand that, we have to take a look at Griswold v. Connecticut.
Okay.
And in a nutshell, Griswold v. Connecticut was a Supreme Court case which struck down a law that prohibited married couples from using birth control.
Wait, what?
Oh, yeah. Yeah.
Hold up. There was a law that prohibited married couples from using contraception.
Yes.
So basically, you're married, you have to procreate.
Yes. And this was a Connecticut state law.
I'm sorry, what?
Yeah.
What? Okay.
Well, you also got to remember at this time, there was also laws against interracial marriage.
And yeah, I mean, that didn't change until like the 60s and 70s. And in some places, 90s.
The Loving case in Virginia in the 70s.
Yeah.
Okay. And so in Griswold v. Connecticut, the court affirmed that the First Amendment to the U.S. Constitution guaranteed a right to privacy, even though it does not explicitly say so.
Okay, so this is the Connecticut one.
Yes. So you have the Supreme Court saying that there's a right to privacy in Griswold.
Okay.
And so they've taken this right to privacy that is implied in the First Amendment, but not expressly stated. We'll say that, and said that it is a fundamental right of a woman to decide whether or not to terminate her pregnancy because of this right of privacy of the First Amendment.
So that's what Roe v. Wade established.
Yes.
Okay, so
now
Roe v. Wade focused on the abortion aspect of that privacy, whereas that previous one focused on the just contraceptive portion of that privacy?
It focused on basically the marital privacy.
Okay.
Contraception was part of that, but there is an implied right of privacy.
So that's where we get the implied right of privacy from.
Right.
And that statute was, what was the year that happened? Because that was
1965.
okay. So that was in the 60s.
Yes.
Okay, before the
So
60s. Okay, I do have a question actually.
okay.
Before the 60s, did we have that implied right to privacy? Was that there? Did they hold that up, or did it not?
It was not specific in the Constitution, so no.
So it wasn't until the 60s that we started holding up that right to privacy.
Right.
So before the 60s, the government basically could come
The
in. I
the
mean,
only right you had was the right against unlawful search and seizure, guaranteed in the Constitution.
okay. But that doesn't
Explicitly.
mean that they can't, like, what is it, the NSA? That doesn't mean before this right to privacy you didn't have people like I mean, that just means that they can tap into phones and stuff legally, right?
There was specific laws against federal wiretapping
Oh, okay.
that required a warrant, but absent those laws,
Right.
possibly not. That would have gone to the Supreme Court, and they would have said either one way or another.
So it's very recent that this right to privacy has been established in the Supreme Court.
Yes.
Wow. Okay.
Okay. So, and they called it a fundamental right, which is very important because when you're doing judicial review of the constitutionality of certain laws, a fundamental right is different than, say, a statutory right. And so, when they look at a fundamental right, they do a test which is called strict scrutiny. And strict scrutiny is a form of the judicial review that requires that a legislature must have passed the law to further a compelling government interest and must have narrowly tailored the law to achieve that interest.
I'm sorry.
Okay.
I
Yeah.
think I know what you're talking about. No, I don't. I don't.
Okay.
You're gonna have to. I'm confused.
Okay. For a law against a fundamental right to be constitutional, there must first be a compelling government interest.
Okay.
Not
What would be a compelling
any.
government interest then to? So what you're saying is, in order to overturn Roe v. Wade, there needs to be a compelling government interest in order to do this.
Right. And
Okay.
here's the second part. In order to achieve that compelling government interest, the law has to be narrowly tailored, which means
Meaning what?
the least restrictive way of achieving that compelling government interest. Now,
Can you give
most
me an example? Because that I'm still a little lost on that.
okay,
Like narrowly, like when you say it needs to be narrowly, like it has to focus specifically on that government interest.
right.
So it can't be like what SB8 is, which is this broad thing. It has to be it has to be way more narrowed and talking specifically only about government interest in not allowing women to have an abortion.
Right. For example, what is the compelling government interest in the 6-month mark or the 6-week mark?
There is none.
The law is designed to stop abortions in the state of Texas.
Right.
The authors have admitted to that. So
Right.
is stopping abortions a compelling government interest?
I, I don't I don't see how it would be, because it doesn't it's a personal thing. It's not, it doesn't, me having an abortion, or a woman, a person who can carry a child having an abortion, has nothing to do with the government, how it works. It doesn't, having a child and not having a child doesn't really affect the government. In fact, if really having the child affects the government more than not having the child. Because if you have the child and you can't afford the child, well, then you have to go on welfare, and then you have to go on government assistance, because you can't afford to take care of that child and nobody else wants to help you take care of that child. So it's actually in the government interest to allow abortions.
That's an argument.
It's a damn
And
good one, isn't it? You're
I'm
you're
I
you're you're trying to not be opinionated. You're trying to let me be the one with the opinion because I'm the one with the uterus. And I get that, and I appreciate that, and I respect that. But that's how I feel. Like, me having a child does not literally does not affect anybody else around me other than you and my
okay.
parents, right?
Well,
Like,
I'll play devil's advocate with that. You having a child increases the cost of, say, government public schools, because the more students you have, the more money needs to be budgeted. The
I
more
already
money,
pay taxes
the more money
for
that
those
needs to be budgeted,
schools.
the higher the taxes need to be.
But I already pay taxes and I don't have children. So how does that affect anything? Okay.
Because if someone has more children, you're going to eventually pay higher taxes, whether or not you
Okay.
have kids or not. So when you say it doesn't affect, there is a collateral effect. It's
Okay. There isn't a okay, well, that just goes, all that does is go back to the argument of why you want to have abortions, because then you're not adding another butt in a seat. You're not adding more taxes and taxing the system, because you're not bringing that parasite into the world. And yes, it's a parasite until it's born, okay? It feeds off of you, it eats everything you ate, it makes you gain weight. It's a parasite. By definition, it's a parasite. A fetus is not a child until it comes out of the womb, because it's connected to the mother. It is just another entity of the mother. Period.
and a legal argument for you is going to be, if it was a person, why am I not getting a tax exemption for it?
And not only that, here, okay, okay, that's an argument, but at the same time, if this is, why is this piece of my body more important than the rest of my body? Because a child is connected, like, it is, okay, as someone
Through the
who
placenta, yeah.
as someone who eventually wants a child, and who struggles with fertility, this is a subject that I know a lot about when it comes to birth, how children grow, how they form, how they, like, this is very near and dear to my heart. I've been in the birthing room with friends who have had their children, and it is the most amazing thing that can ever happen. But it is a personal thing. It is a personal choice. And that child, even when it comes out of the mother, it is still connected to the mother. Until you clip that cord, that child is part of the mom. And I don't understand how people cannot grasp this concept It's like a wart growing on your finger. It's a part of you. It looks like, or a pimple that just like takes up half of your cheek. It's a part of you. You want it to be separate, but it's a part of you. It is in you. It takes your DNA, it's your cells, it's you. It is a part of you. That is what a child being formed in the womb is. So
Yes. And
you
most arguments that it is a person are based on a religious viewpoint.
exactly, which to me in this particular situation is an invalid argument. It is not an argument that you can use. If you choose not to have an abortion, that is on your that is your right to choose. I would never force you to have an abortion because I would never do that. Because I believe that people should be allowed to have abortions. No. The right to choose is the right to life. Pro-life is not actually pro-life because you're completely taking the mother out of the situation. Anyway.
Well, prior to this case, abortions were banned in 46 states.
Yeah.
Okay.
In
So before Roe.
Before Roe v. Wade.
Yeah. So, and I don't know how many states banned contraception. Like Connecticut did in Griswold.
Which is so weird.
That's also a religious viewpoint based law.
Yeah. Obviously. That's a very Catholic viewpoint.
It's a puritanical viewpoint, not just Catholic.
Well, I know that a lot of like Catholic I just remember there's over the years there's been a lot of controversy about Catholic businesses, especially hospitals and stuff, not wanting to provide
birth control
as part of their health insurance.
Yeah.
Because they don't, because of religious freedom. But I just, that's such a gray area right there. Like, okay. Yeah, that's not for this podcast.
Getting back to the fundamental right and the strict scrutiny test, in a nutshell, there are two competing, compelling state interests: protecting the woman's health and protecting the life of the fetus. So what happened was the court divided pregnancy into 3 trimesters. And this is where you get, the 3 trimester test.
I find this very interesting that the trimester. So before Roe v. Wade, did we have established trimesters? Like, did people understand?
Medically, yeah.
So medically, it was trimesters were used, so people did know about trimesters.
Yeah.
So
Yeah.
Okay.
We got the peanut gallery barking behind us. Go lie down, Remus. Okay, so during the first trimester, the court gave the guideline that the decision to terminate the pregnancy was solely at the discretion of the woman. And after the first trimester, the state could regulate procedure. And during the second trimester, the state could regulate but not outlaw abortions in the interests of the mother's health. And then after the second trimester, when the fetus became, quote, viable, the state could regulate or outlaw abortions in the interest of the potential life of the fetus, except when necessary to preserve the life or health of the mother.
So that's what was established in Roe v. Wade.
Yes.
So even with Roe v. Wade, the states could still come in and say, nah, you can't have an abortion because it's too late in the pregnancy.
Right.
I a fetus is viable after I believe 20, I think
It
I know after 30 weeks a fetus can survive. I think the earliest is like, I want to say 20. I don't know. I don't
it
know on
it's
that.
it's become less and less since this was enacted.
What do you mean, the
Gen-
viability of a fetus?
yeah, because of the advance of medical technology. So at this time, generally, the second trimester ended at 26 weeks. So if you're in your 27th week of your 39-week pregnancy period, the fetus was generally viable.
Yeah, okay. I
Okay.
think the current is I think the earliest right now is 21. But I mean
Right.
that's very rare that they will survive that early. Um like it's still, when a baby is born that prematurely, it's still a very high risk for them to survive.
Yeah. Oh, yeah. But viability does not mean certainty.
Right.
Okay. So it's the period of viability has expanded as technology gets better.
But that, and I don't think viability then at this point, I don't know that it ever should have been used, because like you just said, viability doesn't mean probability. Viability doesn't mean they're definitely going to survive. It just means that possibly could survive.
Right. So
Um,
here you have the problem of competing compelling state interests.
okay.
And the court caught between, what the hell are we going to do? We have this privacy right. There's a compelling interest in the life of the fetus. But there's also a compelling interest in the life and the health of the mother. So they came up with this guideline, as the court does give guidelines every so often when there's some kind of ambiguity like this.
Mm-hmm.
And the court is not perfect, as
No.
can be seen from this, because it's not a perfect system. It is a rigid system. It's easy to apply. First trimester, no problems. Second trimester, you can regulate the process, but you can't outlaw it. And the third trimester can't be done.
But again, things can happen, and I just, okay.
Yeah, well, it can't be done except where necessary to preserve the life or health of the mother. Now, there were some.
I think it's a very rare case in which a mother by the third trimester is going to decide for an abortion. I mean, she's carried that child for, you know, what, 20 something weeks at that point. I mean, you've carried that child for at least 6 months. At that point in your pregnancy, like, unless there's some major issues, the mother is more than likely going to carry that child to term anyway if they are in the third trimester. Like, it's not like it's a, let me try this out. You know what? I'm about to give birth. I don't want to have this baby no more. That's not how it works. That's not how that works. And the way these lawmakers make these laws, they make it seem as if you have this plethora of women out there going, let me get pregnant and then have an abortion at 8 months. That doesn't happen. That doesn't happen. They don't just get pregnant and like do all the pregnant, like, do you know what it's like to be pregnant? Like, I mean, come on. That's not you're committed if you're in the third trimester at that point for a pregnancy. I'm just putting that out there. So
Generally speaking, I agree with you.
these lawmakers are thinking like in these absurd, like they're reaching, in my opinion, for that kind of stuff.
Okay, and uh, now let's take a deeper dive into the actual text of the opinion, like we have before. That was
Mm-hmm.
just a nutshell. So this was brought about, as you know, this was a class action challenging the constitutionality of the Texas criminal abortion law. Generally, in order for
Similar to what's being done now with the current abortion law, the SB 8, where you have the ACLU and all of that
right,
stuff.
right, except that it's not a class action currently.
Okay.
The class in this case was pregnant women. So Roe represented all the pregnant women in Texas.
Okay.
And that's important because generally the Supreme Court will throw out a case that is moot or is no longer um, applicable. For example, a pregnant woman who's had a kid, who has her child, no
Yeah.
longer would generally have standing to bring a
Oh.
lawsuit
Okay.
because, the lawsuit doesn't matter anymore. She had her kid.
Right.
Okay. But here, the Supreme Court said that this is an exception to that rule because it can be brought over and over again. And a pregnant woman, because of the appellate process, would never have their case ever decided because everything would be moot in the 9 months it would take. You wouldn't even get to the Supreme Court.
Right. You would never get a chance to even reach the appellate court because of how long how long this stuff takes. You'd have the baby and possibly a second one by the time it got to the Supreme Court.
Right. So what you had was what they call uh, a a damage or a legal question that is capable of repetition yet evading review. And they consider that an exception to the usual federal rule.
Okay. What? Okay. Hold on.
Excuse me.
What does that mean? What does that legal thing mean? And like, can you repeat
Right.
that?
Yeah. Capable of repetition yet evading review.
Okay. I mean, that I can't think of anything else that exists like pregnancy when it comes to that kind of situation.
I know there is because they've used it before. I did not do the research on it to tell you other examples, but the perfect example is any litigation involving pregnancy.
Right. That's wow. Wow. Okay.
Yeah. So the opinion of the court go down to number one. They throw out one person, Doe v. Bolton. They throw out the Doe portion of the class action as not having any kind of standing to bring it because that particular person was not pregnant, was only being charged with the criminal portion. So they threw him out. They kept Roe. I'm sorry, they sound a lot alike. So
Yeah.
they kept Roe, and if you go down to paragraph 7 of the full text of Roe, you see that Texas first enacted a criminal abortion statute in 1854. and it was generally the same text that was considered in the Roe action.
Which was, can you remind us what the, it was just the general, you can't have an abortion because you got a uterus?
Yes.
You have tits and a uterus. You're not allowed to think for yourself.
It was a crime to procure an abortion, have an abortion, with the except with respect to an abortion procured or attempted by medical advice for the purpose of saving the life of the mother. So basically, it's all illegal unless it's necessary by a competent medical person to save the life of the mother. And there were similar statutes in, like I said, 46 of the states. So here, Jane Roe, and they used an alias that was not her real name, was a single woman residing in Dallas, Texas, and she sought a declaratory judgment that the Texas criminal abortion statute was unconstitutional on her face because she wanted to terminate her pregnancy by a competent licensed physician under safe clinical conditions, and that she was unable to get that abortion in Texas because her life did not appear to be threatened. She could not afford to travel to another jurisdiction in order to secure a legal abortion under safe conditions. And therefore, she claimed the Texas statutes were unconstitutionally vague and abridged her right of personal privacy, which goes to the 1965 case that we previously said, Griswold.
Interesting. Okay.
Yeah. By amendment to her complaint, she also purported to sue on behalf of herself and all other women similarly situated in Texas. And that's where the class action part comes in.
Okay. Now, when did they get women to sign up for this class action, or did they just say this is for all women?
This is for all women.
Okay, so they didn't have didn't have technically other women in on this case.
No.
Okay, interesting. Can you do a class action like that, or is it just this is a special circumstance?
This was not certified as a class action.
Oh, okay.
They wanted it to be a class action, but they didn't go through the formalities of actually making it a class action, it seems.
Gotcha. Okay.
At least from what I see of the opinion.
Gotcha. Interesting.
Okay. So the first 18, 19 paragraphs of this opinion is, can she bring this to the Supreme Court?
So what
because
is?
she
Can
is
you
no longer pregnant.
What's this opinion again? This is the opinion from the Supreme Court.
Yes.
Okay. So this was post the.
This is the full text that I'm going through.
So this is the decision that was created. This is what the decision was said after they went through the whole process.
Yes.
Gotcha.
And
how many pages is this total?
It's a lot of pages.
Is it like that 110 page opinion piece from the dude in Texas?
It's not that big, but there is about 100 paragraphs.
That's a wow. That's, I mean, I think this is really important though, because this is what our Supreme Court said in the 60s. So they're gonna have to reference back to see what the Supreme, our Supreme Court, our current Supreme Court is gonna have to look at this and really think on this stuff.
Right. Because, and I'll just say this before we get into paragraphs 18 and 19. How can you overturn this without saying that there is not a right to privacy?
Right.
Okay.
Before we go any further, We're actually at about 50 minutes of
Yeah.
live. Uh, would this actually be a good place to pause it?
No.
Okay. So you want to
I
go a little bit more?
I will go through paragraphs 18, 19, and 20. That will bring us to about an hour,
Okay.
and that will pause it. And it's nothing I really said, but I want to read the actual text so
Gotcha.
people understand. Okay. 1 through 17 goes through a whole legal argument as to whether or not she can actually bring the case.
So
And so the
basically, it's establishing why they allowed this case to come through, uh, what their legal acceptance of it because of the situation, and why they made exceptions for this particular case, because it is a very nuanced case. It's a very, special. It's a special thing because of the situation at hand. So that's what
right,
all of those are about.
right. So, paragraph 18, quote, the usual rule in federal cases is that an actual controversy must exist at all at stages of appellate or Supreme Court review. That was a paraphrase. They use the term certiorari, which means Supreme Court, um, and not
Never
simply
heard of
at
that word before. I would
yeah,
have read that as certiorari because of how it's spelled.
yeah. When the Supreme Court takes a case, it's called granting certiorari. You know,
Certiorari. Okay.
I I will mispronounce this word every single time and pronounce it a different way every single time.
Okay.
That's just the way I am.
So basically,
Okay, so
Supreme Court review.
yeah, the actual controversy must exist at all stages, at the beginning and at each stage of the appeal, and not simply at the date the action is initiated, i.e., in this case, just because she was pregnant when the lawsuit was initiated. The usual rule is that she would have to be pregnant at all stages, and they cite the cases
Right.
for that.
But unfortunately, that's just not a viable thing.
Right. So they go into paragraph 19. But when, as here, pregnancy is a significant fact in the litigation, which quite simply, it's an abortion case, so pregnancy is a significant fact. The normal 266-day human gestation period is so short that the pregnancy will come to term before the usual appellate process is complete. If that termination makes a case moot, pregnancy litigation seldom will survive much beyond the trial stage, and appellate review will be effectively denied. Our law should not be that rigid. Pregnancy often comes more than once to the same woman and in the general population. If man is to survive, it will always be with us. Pregnancy provides a classic justification for a conclusion of non-mootness. It is truly capable of repetition yet evading review. And then they cite many cases.
That's a long list of cases. Are these all cases where
Yeah.
pregnancy was important, but they didn't make it through because they.
Not necessarily.
Okay.
These are cases where there was something that was capable of repetition yet evading review.
Oh, so okay. Okay, gotcha. That's a that's a that's a long list. Okay.
Right. And one looks like it's a railroad case. Um, Southern Pacific Terminal versus ICC from 1911.
Yep.
Okay.
Interesting.
And so in paragraph 20, they say, we therefore agree with the district court that Jane Roe has standing to undertake this litigation, that she presents a justiciable controversy, and that the termination of her 1970 pregnancy has not rendered her case moot. So there you go. It took 20 paragraphs of the almost 100 or so paragraphs of the opinion just to uh,
Emphasize that just
emphasize that she could bring this
she could bring this case
lawsuit. Yeah,
even though she's no longer pregnant. And that,
correct.
like, it took 20 paragraphs for them to say this lady has a right to do this.
Correct.
Jesus Christ. Jesus Christ. Like, law's insane.
And so, as a general observation, as the Supreme Court has evolved throughout the ages, their opinions have also gotten longer. You would never get a 100-paragraph opinion back in the early 1800s or late 1700s.
Oh.
Yeah.
Why? Why do you think they've evolved?
Because
The cases have evolved?
you have to cite backwards to cases and precedent. And so the more cases that get decided, the more you have to put in all those
Gotcha.
prior quotes and everything. So
That's a lot.
yeah.
That's a lot. Holy
And
crap.
so this would be a good place to stop. We've established that she can bring the lawsuit. Now, next episode, we'll get into the reasoning behind the privacy issue.
The reasoning behind the privacy issue. Okay.
Yeah. And yeah.
We'll really get into the meat of it next week. Okay.
Yeah.
Wow, that's holy crap. There's so much. There's so much. Well, thank you so much for listening to Learning the Law. If you like this podcast and want to hear more, don't forget to like, subscribe, follow, and share in all your favorite places. Don't forget to follow us on Twitter at Learning the Law. Ron at Necrokijo, that's Necrokijo, and me at Phoenix Nymphy. If you have any questions, please tweet us, comment, or email us at twolazydogsmedia@gmail.com. This has been a Two Lazy Dogs production. Bye, everybody.
Bye, everybody.